Hi, welcome. So good afternoon. Today we have Howard Anawalt talking to us about intellectual property rights. Howard was a professor at Santa Clara University, a law professor for 35 years, starting in 1967. Interestingly enough, Howard, in those days, with the Vietnam War going on, was one of the first people doing pro bono work for draft resistors, and ultimately got a couple hundred people, lawyers, involved, helping out there. He started working in intellectual property in 1979, first as an attorney as well as a law professor representing Atari, and worked at Santa Clara for till 2003, and has written a very well-regarded law textbook, or maybe more, you tell me, and of course just came out with Idea Rights. So let's give a warm Google welcome to Howard Anawalt.
Thank you very much. Hi, I want to thank you, Hi Mervite, and Google for inviting me here today. And I've got a very interesting subject matter to talk to you about. I hope I can do it justice. I want to talk to you about intellectual property, which I'd like to offer to you as a question of idea rights, and let's see why that's the case as we go through these things today. My subject is pirates, playing cards, and intellectual property. So at the beginning, I'd like to just run through some 6 slides that may help us to come to grips with this area of history and law somewhat quickly, I think. First, we have Johnny Depp, and he suggests to us exciting movies that we may enjoy watching. Also, he brings to mind piracy as it's been romanticized in Hollywood and Halloween costumes and the rest of it. It also, the traditional pirate represents a huge part of history, ancient history, and history that's of great interest to Americans and English-speaking people, because it turns out that the pirates were not only hugely vicious marauders at sea, but also had to be skilled seamen, and were early on enlisted by the English and other nations as well to help them triumph at sea and ultimately become masters of colonies abroad. The use of pirates integrates into our story because early on, when trade was flourishing after the end of the Middle Ages, it became clear to rulers and people around the world that exchange of goods and building up of small industries was hugely important for the welfare of any given nation, and to some extent that wealth would trickle down to the people. So let me just run through these slides. The first one is Johnny Depp, and that brings to mind questions of the role of piracy in commerce and in history. The next one, playing cards turn out to be an early example of monopoly powers. This particular monopoly was in England during the rule of Queen Elizabeth. And the next slide is a slide of an exhibit from Carlson's patent, which was the first xerography patent. It was issued in 1942. It's kind of a neat exhibit, a little bit difficult for you to see perhaps, a very nice exhibit displaying the method that we use currently still to produce copies of all kinds. Xerox, to a certain extent, was the original company to benefit from this and had a near monopoly on plain paper copying when the Xerox machine first came out, I think probably in the early 60s. The next is a picture of Oscar Wilde. I'd like to pause on this photograph of Oscar Wilde. It's a little difficult to gather the detail of this colorful man. He was a writer in Victorian times in England, and tremendous wit. And he is taken in that this photograph of him shows a very interesting personality, I think. This photograph becomes a source of controversy when it's copied in the 1880s in the United States and leads to an important copyright decision by the United States Supreme Court. Hi, let's look at the next one. This is an interesting, you see this is a movie poster of a movie that starred Kirk Douglas. It's actually a movie that got Billy Wilder's career off to a good start as a Hollywood director. It also led to a kind of an interesting lawsuit where the California Supreme Court warned people who have hot ideas that they have to be careful about who they disclose them to, because as the California Supreme Court elegantly put it at the time, the idea man who blurts out his idea and loses it has no one to blame but himself. So already checking in here, I have been asked to observe a confidentiality agreement, which Hy assured me was all up to me, but I went ahead and agreed with that. And I've also signed a release so we can put these things on YouTube today. Now let's take a look at the next one. This is going to be an interesting story for us. This has to do with a trademark case. Just a few years ago, some very enterprising women in Nevada decided that they wanted to produce a whole line of dog toys. You can imagine that probably the biggest threat to Google's business today must be the upsurge in all kinds of products that are produced and purchased for pets, everything from gourmet meals to Louis Vuitton purses for them to have. This, you can imagine, if I just looking at that photograph, did not please Louis Vuitton terribly much and led to a lawsuit. And I think maybe the next one, do we have one more? Or does that bring us, it brings us back to Johnny Depp. Okay, now I think we just shut that computer and we'll be done with it. Okay. All right, so if you can recall some of those photos, let's start with the first one, the second one actually, that has to do with the playing card monopoly. The rights to intellectual property begin to take shape in a culture that's extremely important to us, Anglo-American legal culture, as early as the 12th and 13th century. In fact, the Magna Carta, which King John was forced to sign in 1215, in England, we regard in our country as kind of a source for all kinds of human rights and political rights. But among other things that it assured was that the merchants in England would have free passage to move around the realm and sell their wares, and also that there would be some uniformity of weights and measures in England. These may not sound like enormous rights to us today, but we must realize that at that time, England was still ruled by a system that was called feudalism at the time, but in England had progressed very, very rapidly to being a centralized monarchy with much more ability for a king to determine what was done in the land than not. And that actually was the reason that the barons and other lords and the clergy as well forced King John in the middle of the Thames River to sign the Magna Carta. Our culture regards this actually as a source of things like due process of law. It's the cornerstone of the unwritten constitution in England and very much revered in the same way in the United States. So the playing card, as matters progress from the 13th century to the 17th century, the late 16th century, a very powerful and famous queen, much made of in the movies and in history, Queen Elizabeth, faced threats from the Spanish with an armada that attempted to invade England, cross the Channel with a huge flotilla of ships in 1588. And the English combined the prowess of small seamanship together with good fortune of having had a gigantic storm come up at the time that dispersed the Spanish fleet. But they defeated the Spanish Armada, and I think from that and other things took some lessons away that one of the sources of great merchant capacity at sea would in fact be pirates. All the nations from the 16th century through the end of the 18th century and on into the 19th century used pirates, as a matter of fact, as part of their methods to gain control and used them militarily to gain control of the sea. The United States also used piracy aggressively during the formation of, prior to the United States and thereafter. The reason that pirates come up in our context is both the free use of the term, which I'd like to talk about a little bit later in my short conversation with you, but the fact that it's so closely linked to the emergence of commerce in England and in the United States. The people who made wares and imported them and allowed trade to flow were extremely important, as I mentioned earlier on, for the progress of the English monarchy and the Dutch and all the other nations of Europe that wished to expand their products that were available to people within the realm, but also for expanding their national power. The influence of commerce on England, for example, and extremely important to us, is much was controlled by monopolies, as we saw in that playing card that I just showed a minute ago. In times such as I'm referring to now, 3 or 4 centuries ago, royal power could determine many things. And in fact, almost everything that we can think of that expanded their world traced back to some grant which was issued by a king or a queen. And things that, for example, a king or queen might issue a patent, an open patent, which is what they were called at the time, lettre patent, to a person, famous or somebody that had access to the court to have control over the importation of jams or the production of a certain kind of important timber product. These things could be controlled by royal monopolies that were granted. Also, at that time, the Dutch East India Company and the British East India Company and the Hudson's Bay Company and the charters that established the colonies in Virginia and in Massachusetts were issued by royal charter or by early versions of what we consider to be corporate instruments. In the early 17th century, this degree of enormous control that the Crown had over monopoly was broken by an act of Parliament that forbade all monopolies in England. In short, the statute on monopolies prohibited the Crown from issuing monopolies to anybody. So the word patent really is a term that covered every kind of thing in the times I'm speaking of. A charter to do something, to establish the East India Company, all kinds of grants of power went under this general term patent. It was simply a royal commission or a royal permission to do something, and coupled with it was quite often the assurance that only you would be able to practice this particular trade, import these particular goods, or carry on a certain form of commerce or take charge of such matters as colonizing in India or in North America. The pirates fit into this in part actively. I don't want to dwell too much on piracy, but the East India Company, for example, were given what are called letters of marque that would allow them to, in essence, use the same tactics as a pirate, seize other people's ships, but since they had a letter from the king that permitted that, they would be subject to no prosecution whatsoever. And this, in England or under international law, the same thing would be a protection for them as well. So when we think about the names, for example, in our area here, the Bay Area in California, Sir Francis Drake is a famous name to most of us who live in this area. Both he and Walter Raleigh were pirates originally, though wealthy ones. They were given letters from the Queen to act on her behalf, especially to seize things from the Spaniards whom she was in competition with. She would politely deny to the ambassadors that she was involved in any such thing, but the active use of this kind of force and the fact that they could stimulate commerce and encourage trade at seas for those who commanded them was an active part at this time as well. So the Act of Parliament that eliminated monopolies had an exception to it, and the exception was that you could receive a monopoly for 14 years if you created some new method of manufacture that was valuable and hadn't been practiced before in the land. That monopoly was good for 14 years. After that, it expired. We can easily see the close relationship to our own patent laws today, which are strikingly similar to that. The patent laws today permit you, if you come up with a new method of manufacture, a new combination of matter, a new process, if you do any of these things, you also, if you, today now the law has changed somewhat just 3 weeks ago, but if you are the first or your company is the first to file for a patent and the patent office agrees that this is something new, that it's useful, and that it's not an obvious thing for people who are skilled in your trade, you get a monopoly over that for a period of 20 years, which entitles you to practice that invention and forbid anybody else from practicing the invention. The next thing that emerges historically is what we consider to be copyright. And the copyright laws began to take form as we know them today as an exception to something that the Crown greatly desired to control, and that was the free flow of information. Because when Gutenberg first made it possible for people to print books, this presented a kind of political threat, an organizing threat to any government, and they wanted to be able to be the ones that would control the flow of information. The copyright laws slowly emerged as an erosion of that and granted originally the copyrights to publishers, but later on in our system to the authors of new things. So we now have, in our Constitution, the Congress has power to create two branches of important intellectual property law. One is patents, and the other is copyright laws. A patent in our country, you have to apply for the patent, and a patent officer has to examine it carefully and study all kinds of prior art, that is, things that have already been done in the field, and determine whether yours is new in the sense that the patent office requires that. The process is one that demands, it's not an aggressive adversarial process, but if you speak with patent lawyers, they'll tell you, my job is to be very courteous with the patent office and to disclose everything that I have to tell about our invention, what we think that other people have, prior art and so forth, because a falsehood in the declaration process and the treatment of matters with the patent office could perform a fraud on the whole system, and the courts recognize that and would undermine your patent, because if it was procured by in essence hiding the ball from the patent office, that undermines the entire system. Copyright, by contrast, is immediately something that you own as soon as you in any way copy down information or express it in any kind of a medium whatsoever. For example, if you're jotting down some notes or typing on your computer while I'm speaking, taking information down, you can't own those ideas. First of all, they didn't come from you, and for that matter, there hasn't been really a single original word from me this morning either, so I can't claim that I own them. And your expression of those things, however, if you're doodling on a paper or something, that is your expression, and that's the kind of thing that you have ownership of. Now, looked at from a lawyer's perspective or a practical perspective of anybody who works in a creative field, such as many of you do, the patent gives you quite a clear definition of what it is you own. It's a little bit like the pink slip to a car, or what is spelled out for you in a deed to real estate, except in the case of a patent, what you get is a description of what you claim your invention is. So as you work to spell out your claims and present those to the patent office, it is what the patent office will agree with you is new in what you state your invention is. So that is a rather clear indication in advance what it is you own under the patent. So you can go look up patents in a field such as the field of doing searches by means of computerized methods. For example, the patent that was originally filed by Larry Page and issued for an important part, I'm sure, of Google's origins here. You can find out what was claimed in his patent or any other patent and attempt to follow those limitations. I want to quickly mention that this comes from a constitutional provision. There are two constitutional provisions that I think I should mention here. One is the Patent and Copyright Clause. The other one is that the Constitution reaffirms how important pirates were because Congress had the power specifically spelled out in the Constitution to grant letters of marque or reprisal. And what that fancy language means is it's quite old terminology that started in about the 13th century, which a letter of marque converts the most infamous kind of criminal, one that was beyond anybody's jurisdiction, a pirate at sea, suddenly into a completely protected privateer. So everything is in the name, isn't it? As long as you have the patent from the king or queen to operate as an authorized pirate. And the nations of the world actually observed this. They might not observe it in one sense. If the piracy was so bad and they thought they could win, they would go to war. But that was the only recourse against privateering. So we have two constitutional provisions that come into play in this conversation today. I want to quickly talk about the Oscar Wilde case, the picture, the photograph, if you recall, of Oscar Wilde. I have to be careful of my time here because it is short and I can get a bit long-winded, and I do want to leave some time for questions as soon as possible. But the photograph that I showed earlier on, the picture of Oscar Wilde, presented the following problem to our copyright laws. The photograph was taken by a famous photographer at the time. His name was Napoleon Cerrone, and he was a Western type of photographer of his day. He was very famous. His photography commanded a very high price, and his photograph, the one that we saw, was copied by a lithography company in New York or Boston, I think it was New York, and widely distributed and sold for a much smaller amount. It was a pricey copy in those days. I can't remember what the figure was to you, but it was not any cheap photograph, but it was a lot less than Cerrone would have charged for his originals. Well, Cerrone rode off to the courts and demanded that he be compensated for this taking of his copyrighted work by this other company that simply did a knockoff of it. And the Burroughs company, which had made the copy, argued to the trial court, and I think they probably won at the trial court stage, well, this is not the work of art of Napoleon Cerrone. It's much like this video camera that's running on me right now. It's just the operations of a machine. So there can't be a copyright on behalf of Cerrone. because first of all, this is not a work of authorship. It's just a product of a machine. And the court had to determine then whether there was authorship at all on the part of the human being, and that was difficult, because after all, the photograph is truly taken by a machine. The court reasoned, though, that the posing of Oscar Wilde and the dramatic positions that you see there, the lighting, all these things, that the human contribution did allow Cerrone to prevail as a copyright claimant. Now, I'd like to skip over, since I'm conscious of time, and get to Louis Vuitton, and come back, if there is time, to talk about the need for trade secrecy. And if you are developing ideas, one of the first ways that you go about it in a business organization, or even if you're starting out on your own, is to keep your ideas enough to yourself so that somebody else doesn't run off and do the thing that you want to do, and take advantage of those things before you do. If you recall the Louis Vuitton example that I put up on the board, does somebody have Chewy in the room? Is it being passed around? Oh, good. Can I just have Chewy and show you what I'm talking about here? Where is Chewy? Okay. This purse was manufactured. You can tell that's a purse, right? So this purse was manufactured, and it does have some kind of resemblance to other purses that we've seen, I think. This purse was manufactured by a couple of women in, their company is larger now, but a couple of women in Nevada started manufacturing dog toys, and dog toys could be spoofy items or various different kinds of items. This was one they came up with, the Louis Vuitton. And this toy did not please Louis Vuitton's company at all. At the time I wrote the book that I referred to, I think that the trademark value of Louis Vuitton, which is the primary item of value of the entire company, really, when all is said and done. They may make very fine goods in terms of production and care taken, but the price that is charged for their wares and so forth is based on the value of the trademark. So Vuitton did not want to have their trademark diminished in any way. American trademark law currently provides for famous brands to be extra protected under the trademark laws, and Louis Vuitton certainly qualifies as a very famous trademark. I think that Forbes does a survey of these things every year. At the time that I was writing this book in 2007, I believe that they were number 17 in the world, and the value of just the Louis Vuitton trademark at that time was, I think, $19 billion. So when Vuitton sued, which they did immediately, sued this company, they had what seems to be quite a good case, because there is some ability to recognize the Vuitton type of color and use of symbolism. And so Vuitton was able to claim, well, look, you're trading on our name, in that people may think that this is a product that we have produced, and thus they will be less inclined to rely on the strength of our product being a good one. And furthermore, this interferes with our famous brand. A friend of mine pointed out to me that, among other things, federal judges get a lifetime publishing contract, and none of us have that, because every time a federal judge writes an opinion, there's a good possibility that it will be published, and many of them are. And the judge who handled this case in the first place heard all of the evidence, and he wrote his opinion beginning with the words that, "The court has received quite a dog of a case, and having chewed through the record, I find that Louis Vuitton does not have a claim against this company that produced Louis Vuitton, because, in short, it's joke, and it's a parody, and it does not undermine any of the values that Louis Vuitton could properly claim in the case. So they won. Louis Vuitton promptly went off to the Circuit Court of Appeals and once again won there. So the result of the case is to allow a kind of fair use. And I want to begin to wind down. You've got a phone here, maybe. This is set to go off and assure me that I've talked too long so we can have some questions in just a few minutes. So I want to draw my remarks a bit to a close here. I have a great interest in trying to make the doctrines of intellectual property extremely understandable to anybody, because I think that in times like ours, almost everybody has to have some knowledge of what intellectual property laws are. If you're working in business, even if you have a small shop in town, you have to be careful of things like trademark. So while there's a good deal of detail, there's some summary items that I can summarize for you. Generally, a patent gives you the right to control something for a reasonably long but reasonably short period of time, 20 years, if you can prove it's new and so forth. A copyright gives you a nearly eternal kind of control when you think about modern times. For an individual, the period of time is lifetime plus 75 years. The difference between those two probably was originally based on the idea that patents protect things that people tend to rush to get in any market. There's this traditional way of expressing that if you make a better mousetrap, the world will beat a path to your door, and patents allow you to claim control over better mousetraps. Now that doesn't mean that all patents are particularly valuable. Many of them are not. But we can easily understand that if you had a patent over plain paper copying when that first came out, that would be a powerful tool indeed. So copyrights probably came much longer periods of control because they dealt with the problem of people whose wares and creations were not as immediately commanding, at least in an industrial society. Today it's a very different thing because a lot is paid for entertaining things and things which are not necessarily of ultimate importance, like a new patented process of some kind. So originally these long periods of time were granted because you wanted to take care of the starving artist, I would think, something like that, which is not the case today. I can quickly illustrate that to you because things that are as mechanical as operating systems and software should be protected by patent law if they're new and useful and really accomplish something in the physical world. On the other hand, they shouldn't be protected by copyright because the copyright law forbids you from learning systems and ideas and methods. It clearly forbids that. But the way these things work out, a patent can cover a piece of software if it's new and it hasn't been done before. Most software patents are probably invalid because they are so obvious. But if you get past that hurdle and truly produce something new, you may have patentable software. On the other hand, all software is ultimately, at some point, an expression in some language, so it fits the literal terms of the Copyright Act. See, this is a case of an overlap. I want to leave you with a couple of thoughts. One of them is that the overriding rule of intellectual property, when looked at from the perspective of a social tool and a daily business and production type of law, starts out with a major premise that everyone should be free to use ideas and engage in a lawful profession or business of any kind. That was the reason for the statute on monopolies, to stop the Crown from controlling the production of jam or playing cards or pulleys or whatever else. The basic premise, and this continues in our constitutional statements about it. In order to have a patent, you have to produce something that advances science or the useful arts. Science, oddly enough, in our language refers to knowledge, and thus originally was probably intended to cover copyrights. The useful arts, on the other hand, have to do with things that you can get done, that are patents. So the commitment to having intellectual property laws at the federal level is clearly to assure that only those things that should be granted patents or copyrights are ones which serve a larger public. And in fact, recently the Supreme Court, in quite a famous case, that returned software patents to a properly restricted domain. Justice Stevens reminded the court of something which it had said repeatedly in other cases, that the purpose of patents and copyrights is not to create private wealth. It is only to advance science and the useful arts, and to do so by a reasonable reward to those who create something. So its purpose, according to our background, is not to create piles of wealth, but just to encourage inventive activity and see that it is reasonably compensated and not otherwise. The other thing that I do want to mention to you is that intellectual property laws we can see fit into a social context, and the social context, like the advance of commerce, itself is intended to serve a broader public. Because the method of creating great power within England and in the United States was, on the part of commerce, people who were engaged in commerce or small industry before the Industrial Revolution had to contend with the mighty power of those who held land and those who commanded armies and those who were in charge of monarchies and their bureaucracies. The way that they changed the structure of the society was to gain more and more power through acts of parliament and other things that worked through the legal system to recognize the value of commerce to an entire community, not to just those people who would benefit from it. Because after all, they had to persuade those who would enact laws to go along with the values that they could bring to the community by producing new things or bringing them into the body of that community. So there's a constant interplay in the development of our laws, all of which keeps coming back to how good is this for the rest of us, the people who are in the entire community. And as we know today, we have seen a tremendous surge for democratic movements starting earlier this year in Egypt and other places, and of course extending to this very day to our own country, starting in Madison, Wisconsin, and today there are protests going on around the country to try to determine what the voice is going to be from an entire people in creating the laws that serve us. This relates to the subject of intellectual property because we realize what a huge power it is in the structure of industries and the flow of goods around the country. Trademarks alone have an enormous power over all features of commercial and productive life today. So the concerns that I'd like to leave you with are, first of all, it's an interesting subject and one that's extremely practical for you. You can understand what a copyright is. You can understand, and that is something that, an idea which you've expressed and your expression is protected. The patent is something which you've been able to convince people is new and useful and not obvious to a community that does things all the time. Trade secrets, you have to get these non-disclosure agreements in place in order to assure that you have tried to keep something to yourself. Otherwise, the world should have benefit to it. You have other ways of protecting it. Get it patented, for example. Trademark is different in that it doesn't have to do with inventive activity, but has to do with, originally with marking of goods. So these are interesting subjects. They're valuable to us in daily lives, and they are ones which present to our entire society questions of what should we do now? What are appropriate ways to structure our laws that will enhance moving ahead, but also help us to work as a strong community to protect and improve the hopes of our now heating up planet. Because today, when you think of serving the public interest, in the past, it could always be conveniently viewed as my community, I'll serve England, I'll serve the United States, but today, the public interest really must be conceived of in broader terms than ones that are strictly narrowed down to one nation and one people. I've enjoyed speaking to you. I'd like to be able to answer any questions that you have if there's time for that. Thank you. Any questions? Yes. Oh, sure. Let me hand you that. Why don't I just, yeah, go ahead. Yeah. We'll sort that out.
So the U.S. Patent Office has been overwhelmed with patents or attempts to patent for genes, for biological things like that. How does that serve the public interest?
It's a very good question. Part of the overwhelming aspect, his question is how does it serve the public interest to have a logjam in the patent office? Is that more or less captured?
And particularly with respect to patenting
Yes.
biological.
Yeah, that's a very good question, particularly with respect to patenting biological organisms. There are two difficult things to solve there. One of them is the inherent public interest question of how much should human beings be able to patent things that have to do with laws of nature, expressions of nature. I mean, each one of us is enormously wonderful, complicated Google search engines when you get down to it. And we have this powerful intellect built into us and physical capacities. We tend to isolate that thought to our brains, but gee, the ability to throw a ball involves such an immense computation process running through the entire body. It's very difficult, however, for a patent system to say no to laws of nature in that sense, because in a certain way, almost everything that is patentable comes from a natural force. We don't create all the forces, we harness them. So there's a big difficulty there that I think we could discuss more, but I'd like to turn to the second part of your question, that is log jams. The Patent Office is bound to be log jammed in every conceivable area today because they're required to sort out what is new and then look at a vast area of things that are being done today, that have been disclosed, have been practiced yesterday, or that may be common understandings for people that work in laboratories, or carpenters. They amaze you if you realize that they can do things that you can't do. What if you could patent all those things? So the sorting process is intended to serve the public interest, very strongly so, by being sure that you won't have taken away from you your ability to do the things that you would do anyway, just because somebody ran to the patent office and got a patent on it. So the sorting process is difficult. The public interest questions of how much one should be able to patent things that are part of a genetic structure, particularly a human one. Nations are taking different approaches on that. The United States is not in accord with the Europeans on that subject, for example. Are there some other? I want to catch all your questions, so just catch my attention or run to the mic. Yes.
So since we're here at Google, I was wondering if you wanted to say a few words about Google and these issues. And I know there's a chapter in your book talking about Perfect 10 and Google in that
Sure.
law case and how we relate as a company to this.
I almost think I might have planted your question. Sure, I'd love to answer this question. It's a very, very large question, and I've only just microscopically but paid attention to the news and the San Jose Mercury featuring the two Larrys meeting in court and all of this kind of thing, because Oracle is suing this company based on a patent portfolio that it has. It's bound to be the case that there are going to be patent and copyright and every other kind of collision among large forces and small ones. Google, sometimes I have access to powerful search engines that are focused on law. I can use either Lexis or Westlaw. Since I write a professional book for Westlaw, I tend to use that one almost exclusively. I'm okay because ding, da 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 da. They don't have to worry, it'll quit. Okay, that tells me to shut up. But now I'm free to continue talking because Hi's talking. Okay, sometimes I run a search on the parties to lawsuits, and Google has an astounding, well, it's not astounding, it has a large number of lawsuits to which it's a party. That is, it's either a defendant, as in the Perfect 10 lawsuit, or it is a plaintiff. That is, it's seeking to take care of itself against others in the courts. Google has had some extremely interesting cases, one of which is actually, in short form, is produced as an entire appendix in this book, Idea Rights. It's an extremely interesting case. Google and Amazon and some others you may know about this case, but not all of you. But Google was Google and Amazon were sued by an online girly magazine that started out as a glossy publication, Perfect 10. You can go online and see, you can see women with very little on, if you wish. So Google was sued because people would download the high-resolution images from the Perfect 10 magazine, and then they would upload them back again. And Google, through its search engine, assisted the distribution of these things to people who might download them themselves. So you might have the online subscription to the girly magazine, and you might upload this picture of this scantily clad woman, and I would download one of high resolution, and then the accusation against Google was that it was a participant in the violation of the copyright over that original copy.
AT&T too.
Pardon?
And AT&T too, as the owner of the wire.
Yes, well, I don't. They could be, but that's a little different problem in that all that is a conduit and no selection process whatsoever. So it is like just a wire. But that's a very good point. Let's pursue your point on the way to his. Okay, anyone then that transmits information could be part of the system that takes someone else's right to a copy away. That's what you're saying. And that could be literally true because copyright is something like dynamite. It creates strict liability. If you make a copy of somebody else's material or assist in that, you can be strictly liable for a violation of the copyright. However, if you are only providing the means, like, for example, if a copy machine by the same thought process would say, well, if you produce a means of being able to copy it all, therefore you're party to the copyright. So the copyright law has sorted this out to say you have to have something to do with the decision-making process of making the copies. If it's sufficiently involved on that, then you could be held liable. And that's the argument about Google. Google had produced a search engine which allowed the people to find the photographs that they might want to make copies of, the digital photographs. And so there were two kinds of photographs, all of which was found to be fair use as far as Google is concerned. There's a photograph here of a, I don't know how many of you know what a card catalog is in a library. But the way that you used to find things in a library is to go to a very nice looking oak thing that had a bunch of index cards in it. And you'd look up, really a neat way to browse for things, as a matter of fact. But you would then look up and go and pull down a book and find, well, basically in the Perfect 10 case, the Ninth Circuit here in California ruled that Google was covered by fair use because in essence it was producing a modern equivalent of a card catalog that would allow people to search for the images and then download them. The downloading of the full resolution image was nothing that Google was responsible for, and in fact Google was not party, it did not take a physical part of that process. It was the search method for allowing one to do that. But one thing Google did on the way to this, though, was to use the thumbnails that are part of Google's search means today. So in other words, you not only look at words to find things, but you'll look at a thumbnail and say, oh, that's what I want. For example, I would look at the thumbnail of that Oscar Wilde picture. I want to tell you about that picture. But I would look at that thumbnail and say, that's the one for me. Now, the Oscar Wilde picture was produced in 1890, and certainly there's no copyright on that today. That's the only image I paid a royalty on in that book, because I wanted my publisher to be sure to put that in a high resolution. So there's a company called Corbis. I think that they're owned by Microsoft, but I don't know. But they have an image library of a whole bunch of these things that are at high resolution. They have the copyright of the scan of that, but they don't have the copyright of the original. And I wanted to be sure that my publisher wouldn't put some lousy copy in there. But Google is involved in a huge amount of questions about intellectual property. Hai told me today, now look, you don't have to sign the non-disclosure agreement when you punch the button there. Well, I think I said yes, but that starts the process. You want to be sure that the efforts are kept within the company that the company is trying to work on. That's basically what's behind that. So does that answer some of your questions? Yeah, you had a question.
I think this raised a lot of questions.
Yes, I think so too.
So the digital scan of the previously expired copyrighted picture can be copyrighted? The little thumbnail image creates a copy that is subject to copyright?
Yes. Yeah,
Reformatting for your phone to the proper resolution might be such a copy?
Yes, the answer to that is without a doubt yes. A copy is created, and the copy by a digital scanning is in fact new. If you, for example, were to dot, 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 like that, you would be making a new image. It would even qualify as an expression, because like Oscar Wilde, you've gone through that, and the machine goes dot, 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 dot. In fact, any machine that creates a digital image is creating something from an analog into a digital copy. So we might have some argument about that, but the copy part is almost always present. And the strict liability, that is, making a copy makes you subject to copyright liability immediately, but the courts have reasoned that if all you are doing is to be the physical process of it and nothing more, we have to cut short your liability for providing the means of somebody else to make the copy. So if you have the equipment to make the digital copy, for example, I have a scanner at home, the fact that I scan may violate both the original artist's copyright, and it also creates a separate copyright in me but that I have of the scanned image. But the fact that producing a means to do this is not enough to create your liability. So that's one question that's answered. Almost everybody a copy is a copy, no matter how it's done. But what happens after that is the copy a copy of an expression or the copy of the underlying ideas? If that's the case, that's not subject to copyright. The second thing is there is a very important privilege to copy things. That is, if there is fair use. For example, I probably could copy, well, I know I could copy and produce before you an image that had just been created 2 weeks ago, an artist's drawing of some kind, as long as I'm doing it in a manner only to inform the people that I'm showing this is an example of a copyrighted work, and I don't show too much of it or don't broadcast lots of copies. And this fact that we are being YouTubed today creates more severe copyright problems in terms of fair use, because I know very well that I may be broadcasting an image beyond just this audience here. So copyright is a highly balanced set of rights. It is built into it an assurance that the public should always be able to make fair use of things. I go bananas every time I watch a DVD and see this horrendous FBI is watching you and everything you do, any copy you make should send you right to jail and you're awful. Well, that's just not true. And most of those things are a distortion of what the federal copyright law provides. Other questions?
I think it's actually 1 o'clock.
All right. Thank you very
So
much.
thank you very much.
I appreciate that.